Welcome, good evening, good morning, good afternoon, wherever in the world you're joining us from. My name is Dr. Emily Jones, and I am a senior lecturer at Essex Law School. And I am, of course, also the co-founder and co-convener, alongside my colleague who you see on the screen, Dr. Meagan Wong, of the Public International Law Lecture Series. It's really my pleasure to be your host for today's lecture by the fabulous Professor Ursula Kriebaum. And I will be handing over to Dr. Wong shortly to introduce our speaker fully. But before I do so, I just wanted to say a few words about the series. So this is the third year now of our series, which we co-founded together, Dr. Wong and myself. And we're both generalist international lawyers, but Dr. Wong is a formalist and I am a critical international legal scholar. The series is therefore built upon our deep respect for one another's scholarship, as well as, very importantly, our friendship. The series prides itself on building on these two important intellectual traditions of international law, formalism and international legal practice on the one hand, and critical international legal theory on the other. Just a quick kind of preview of what is coming for the rest of the term, and do join us for these lectures. We have coming up Dr. Mamadou Evi, Professor Douglas Guilfoyle, Dr. Julia Dem, and then a closing session with Professor Patrizia Galvão-Teles and Professor Martins Paparinskis. But of course, without further ado, it's time to really begin today's event properly. And I would now like to take the opportunity to introduce your chair for this evening, Dr. Wong. Dr. Meagan Wong is a lecturer at Essex Law School and is, of course, the founding director of the LLM in International Law. She's a generalist public international lawyer and holds a PhD in international law from Leiden University. Dr. Wong is the author of a forthcoming monograph, which is coming out with Cambridge University Press, entitled Responsibility of States and Individuals, Aggression at the International Criminal Court. Dr. Wong has advised states on a variety of issues in international law and has published on several canonical topics of general public international law, including publications within specialist subfields of international law in peer-reviewed journals such as the International Comparative Law Quarterly, Max Planck Yearbook of United Nations Law, and the Chinese Journal of International Law, among others. And Dr. Wong is also the co-author of a Cases and Materials in International Environmental Law book. So really a very generalist, broad profile, but lots of expertise. So today we obviously have our esteemed speaker, and I'd like to now hand over to Dr. Wong to introduce today's speaker. So thank you everybody for joining us. Dr. Wong.
Thank you, Dr. Jones, as always, for being our fabulous host and such a wonderful co-convener of this Public International Law Lecture Series. Hi, everyone. For those of you who are joining us again, we are so happy to have you back with us. And for those of you joining us for the first time, welcome to the Public International Law Lecture Series. I'm excited to be chairing today's lecture by the very impressive Professor Ursula Kriebaum, entitled The Hague Rules on Business and Human Rights Arbitration and Effective Remedy. Of course, it is only apt for me to point out that Professor Kriebaum is one of the drafters in the team that drafted the Hague Rules on Business and Human Rights Arbitration, and what an honor it is for her to speak to us on this very topic today. Before I introduce our speaker, I just want to go through the usual housekeeping rules. Professor Kriebaum would deliver her lecture, and this will be followed by a question and answer. Please feel free to type your question in the Q&A box, and I will read out your name and affiliations unless you opt to be anonymous. And now I'm very pleased to introduce our speaker, Professor Ursula Kriebaum. Dr. Ursula Kriebaum is Professor of International Law at Vienna University, Austria. In addition to being a member of the drafting team of the Hague Rules on Business and Human Rights Arbitration, she has also served as a legal expert in various investment arbitrations and human rights cases. She was a legal expert in the team of the Austrian Special Envoy for Holocaust Restitution Issues, a delegate to the UN Preparatory Committee for an International Criminal Court, and she was also nominated by the Austrian government for the election of the Austrian judge to the European Court of Human Rights election in 2007. Professor Kriebaum also holds several notable appointments. She's a member of the Permanent Court of Arbitration, a member of the panel of arbitrators under the agreement on the withdrawal of the United Kingdom of Great Britain and Northern Ireland from the European Union, a member of the panel of conciliators maintained by the International Center for Settlement of Investment Disputes, an alternate member of the Court of Conciliation and Arbitration within the OSCE, and member of the Arbitration Panel for the Protocol on Cultural Cooperation to the Free Trade Agreement between the European Union and its member states and the Republic of Korea, as well as serving as a legal expert in various investment, arbitrations, and human rights cases. And of course, Professor Kriebaum is a leading authority in international investment law. Notably, students, scholars, and practitioners all over the world would be familiar with the third edition of Dr. Kriebaum Schroyer's Principles of International Investment Law, of which she is a co-author, as well as the third edition of Schroyer's Commentary on the ICSID Convention, of which she has also contributed to. We are so happy to have Ursula at our event today, and I now defer to Professor Kriebaum to deliver her lecture.
Thank you very much to both of you, Dr. Wong and Dr. Jones, to hosting me here. I'm very happy to be able to contribute to this lecture series, and yeah, very welcome to Vienna to all of you who are listening today. I'm going to present to you the Hague Rules on Business and Human Rights Arbitration, which are a novel approach to the resolution of business and human rights disputes. Why novel? Because in the past, the main focus concerning human rights abuses by business has been on voluntary compliance mechanisms, many of them with a focus on prevention. The effective remedy aspect was less central, maybe not to the discussion and academic writings, but with a view to the instruments adopted. The UN Guiding Principles on Business and Human Rights from 2011 require the existence of effective remedies in situations of alleged human rights abuses by businesses, but of course they do not create them. So over the last 10 years, we can see a development on the international as well as on the national level to move from voluntary compliance standards to binding commitments and remedies. On the international level, the UN, the OECD, and the ILO became active in the field and published documents on the issue. At the domestic level, the United Kingdom adopted the Modern Slavery Act in 2015. France enacted its Devoir de Vigilance law in 2017. Last year, Germany passed the Human Rights Due Diligence law, and currently Europe is still waiting for the future EU directive on a duty of vigilance that will be imposed on all large corporations based in the European Union. It's currently under discussion and will probably include a duty to protect human rights and to offer effective remedies in case of violations. Therefore, there is a growing number of international, regional, and domestic instruments creating two duties for major corporations. First, to do all they can to avoid the violation of human rights. Second, to ensure that an effective remedy is available for the victims of human rights violations occurring in the course of their activities. So what is an effective remedy? Being a European, I usually take the European Convention as a reference point, and it has probably the most diverse case law on effective remedies available so far. So therefore, what does it require? A remedy has to be accessible, neutral and impartial, rapid, and appropriate and sufficient to remedy the damage. So why the Hague Rules on Business and Human Rights Arbitration, and what are the specific features that make them an effective remedy? Let's start with the why and then move to the how. The Business and Human Rights Arbitration project dates back to 2013. In that year, the US Supreme Court ruled in Kubel versus Shell that the US Alien Tort Statute of 1789 has no extraterritorial effect. It denied victims of human rights abuses by companies access to the US courts to obtain damages for alleged violations. And therefore, the idea arose that arbitration could be used as an alternative route for dispute resolution available to corporations and right holders to resolve their disputes in the business and human rights field. The City of The Hague sponsored the project of developing such rules. That is why they are called the Hague Rules on Business and Human Rights Arbitrations. The rules are not intended as a substitute for judicial remedies. Rather, they are an alternative mechanism that in certain circumstances serves the interests of both victims and business and fills the judicial remedy gap in the UN Guiding Principles on Business and Human Rights from 2011. The drafting team designed them with a focus on the special requirements of human rights disputes. Their aim is to provide a dispute settlement mechanism that is in accordance with the UN Guiding Principles on Business and Human Rights from 2011. Pillar 3 of these UN Guiding Principles, the victim's access to an effective remedy, has been given less attention so far. That is where the rules want to close a gap. The rules want to provide a non-state-based, non-judicial remedy for victims ex post under Pillar 3 of the UN Guiding Principles. At the same time, they want to offer businesses a possibility to fulfill their obligations under Pillar 2 to ex ante offer a remedy for human rights abuses committed by them or in their supply chain. In particular, they can enable the enforcement of contractual human rights commitments of business pursuant to Pillar 2 of the UN Guiding Principles, the corporate responsibility to respect human rights. The Hague Rules have therefore a dual function. On the one hand, it's about providing for reparation and a remedy for victims of human rights abuses. On the other hand, the rules are about managing risk of businesses. They are meant to apply cross industries and sectors and were drafted without any particular kind of dispute in mind and are applicable for the full range of human rights covered by the UN Guiding Principles. Let me now turn to the how. The Hague Rules on Business and Human Rights Arbitration are based on the UNCITRAL arbitration rules that are often used in commercial arbitrations and significantly modify them. Let me therefore now highlight some of the key differences of the business and human rights arbitration rules from the UNCITRAL arbitration rules. The process of drafting the Hague Rules required the drafting team to navigate between a variety of goals, sometimes in tension with one another. First, the drafting team needed to keep in mind the function of the rules in both providing reparation for victims and at the same time in assisting business in managing risk. Second, it decided to change the UNCITRAL rules only when needed, but also to change them wherever change was needed. Third, the Hague Rules had to provide flexibility and generality to deal with the multiple kinds of proceedings, for instance, business to business, victim to business, third-party beneficiaries, ex ante versus ex post consent. However, they also needed to provide clear guidance for specific situations related to business and human rights arbitration, for example, concerning witness protection. As a result, the drafting team made sure that the rules would be very flexible, but also included new specific provisions. Fourth, the rules need to respect the autonomy of the parties, an essential trait of arbitration, while providing some clear default rules to reflect special aspects of business and human rights arbitration and the requirements of the United Nations Guiding Principles. As a result, the drafting team sought to balance these two ideas, for example, with important new provisions on transparency, while providing for model clauses that give parties the option to choose their own procedures. Further changes to the UNCITRAL rules concern, for example, issues like arbitrator selection. I will now elaborate on some of these features that are particularly relevant for the rules to be able to provide for an effective remedy. Throughout the drafting of the rules, the drafting team paid special attention to the potential imbalance of power of disputing parties in business and human rights disputes. Various provisions of the rules dealing with issues of inequality of arms between the potential parties of a dispute reflect this concern. Already Article 6E of the preamble reflects this when it hints at the importance of having arbitrators with specific expertise. A number of articles of the rules provide the arbitral tribunal with tools to address inequality of arms issues. One such example is Article 5.2, dealing with representation and assistance. It deals with inequalities that create barriers to access to a remedy, such as lack of adequate representation, language, costs, and fear of reprisals. The article instructs the tribunal to make efforts to ensure that an unrepresented party can present its case in a fair and efficient way. This includes more proactive and inquisitorial as opposed to adversarial procedures. Article 22.4 on the statement of claims offers another example. It provides that the statement of claim should, quote, as far as possible, be accompanied by all documents and other evidence relied upon by the claimant or contain references to them, end of quote. The rule uses this expression as far as possible to allow the arbitral tribunal to take into account the possible imbalance of power in accessing evidence in the arbitration proceedings. This addresses both situations of economic imbalance and situations of power imbalance. An economic imbalance can lead to a situation where the cost of obtaining the documents is prohibitive. A power imbalance can lead to a situation where a party is aware of the existence of certain documents but is unable to obtain them. A reason for this can be that they are in possession of the other party or of third parties. In these instances, the arbitral tribunal may admit a statement of claim and address the issue of evidence subsequently through its power to order the production of evidence or other means of organizing the taking of evidence in the particular proceedings. Article 27 is a further example of this approach. It encourages the tribunals to manage the written proceedings proactively to ensure efficiency and equality of arms without compromising due process. The same is true for the provisions on the taking of evidence in Article 32. It attempts to strike a balance among a number of factors with respect to the taking of evidence. Notably, fairness, efficiency, cultural appropriateness, and rights compatibility. Article 32 allows the tribunal to respond to the possible inequality of arms in the context of access to evidence among the parties. The article mentions examples of tools at the disposal of the tribunal to address these issues. Among them are document protection procedures, the ability to limit the scope of evidence produced, and the power to sanction non-compliance with orders to produce evidence through adverse inferences or a reversal of the burden of proof. It instructs the tribunal to take into account the relevant best practices in the field. Article 32.4 instructs the tribunal to organize the taking of evidence in accordance with best practices and with the overall considerations of fairness, efficiency, cultural appropriateness, and rights compatibility. The article recognizes that document production may be required in order to enable a party to have a reasonable opportunity of presenting its case. The tribunal shall take the difficulty into consideration that certain parties may face in collecting evidence or making precise document requests. Furthermore, it shall consider the potential costs or other burdens that may be caused by document production procedures. Article 32.6 provides for a discussion between the tribunal and the parties of potential difficulties. This will put the arbitral tribunal in a position to be aware of consequences of potential power imbalances in the taking of evidence. It will enable it to determine what evidence may be relevant, material, and necessary to provide each party with a reasonable opportunity to present its case. A very important question in the context of access to a remedy are the costs of the arbitration. Given the resource disparity between the victims and the corporations, why would victims decide to resort to arbitration to resolve its business and human rights dispute when they can file a claim before a national court free of charge in many countries? From the victim's perspective, costs are a problem, yes. But the victim's real issue is to obtain an effective remedy. In practice, the existing system, that is, national courts, does often not provide an effective remedy for business and human rights dispute. Often national court systems are not working as they should. Other obstacles for the victims of human rights violations are procedural difficulties that work to the benefit of the companies, such as the territorial jurisdiction of the courts, no piercing of the corporate veil, etc. International arbitration has in this respect an undeniable advantage. It is based on consent, and if there is such a consent, the procedural and jurisdictional issues in arbitration are much more limited. The rules, like any arbitration rules, cannot provide for a funding system of claims. It is not for the arbitral rules to address financing mechanisms, but we inserted specific cost-saving guidelines and allocation of cost rules. The rules on the fees and expenses of arbitrators and allocation of costs contain provisions that allow tribunals to take into account situations of economic imbalance. Article 53 provides that the costs are borne by the unsuccessful party or parties. However, Article 53(1) affords the arbitral tribunal the discretion to deviate from the loser pays principle and adopt the apportionment of costs that it considers reasonable, considering all the circumstances of the case. The Hague Rules attempt to lower barriers to access to a remedy. Still, parties will need a minimum of resources to cover the basic costs of the arbitration and their own legal representation. This can be either through their own resources or through a legal aid system, contingency funding, or an agreement on the asymmetric distribution of costs and deposits between the parties. Model clauses regarding costs are provided in the annex to the rules. There is also the possibilities that victims will only agree to arbitration if the business accepts to pay for the arbitration. This was, for example, the case in an arbitration between South African gold miners and Anglo-American and Anglo-Gulf Ashanti, which led to the establishment of a settlement trust for the victims. A provision of the rules refers to third-party funders, demanding that their identity be disclosed. Therefore, the rules indirectly acknowledge that third-party funding is also an option. A further alternative could be a system built on a specific international business and human rights disputes fund. This fund could be financed by the states and or independent foundations and or a pool of anonymized transnational corporations. All of that would be options, but the rules, of course, cannot bring into life such a fund. We can just highlight that that would probably be a good opportunity to solve such disputes and to make it possible for victims to have access to this remedy. Now, let me turn to the issue of consent. If a company wished to offer arbitration to the victims of human rights violations, how could it do that in practice? Especially when we know that most of the time, victims are third parties to the contract signed by the company, which they claim has violated their rights. The same could also be a difficulty regarding companies within the supply chain, such as subcontractors that have not signed a contract with the company, but might in fact be the responsible entities. So how arbitration could apply to those situations? There are basically two ways that would lead to business and human rights arbitration with third-party victims or supply chain entity. First, either the company offers an arbitration agreement to the victims or the business partner when the dispute starts or after the dispute has arisen. Second, the company offers arbitration ex ante by granting certain rights to third-party beneficiaries in its contract with its partner in the supply chain, which it could do either by expressly granting in an arbitration clause the right to define third parties, for example, Mr. and Mrs. X, or the workers of Factory X, or the members of Indigenous Group Y, to initiate or join the arbitral proceedings against the company if they claim that the performance of that contract violated their human rights. The annex to the rules provides for model clauses in this regard, under which a defined type of third-party beneficiaries are allowed ex ante to initiate arbitration against the company. In that case, the arbitral tribunal would have no discretion to negate such rights, except for compelling reasons such as a serious prejudice to the arbitral proceedings for which it would have to give reasons. Other possibility would be by granting third parties certain rights in the contract, which contains an arbitration agreement through a stipulation pour autrui, e.g. A and B agree to a contract under which B will render some performance to C. In that case, the arbitrators will first have to determine whether the third party can be considered as a beneficiary of the contract, but under many laws such as Austrian law, but also US and French law, C will be considered as a legal third party beneficiary of that contract, and then balance its interest in joining the arbitration with that of the existing party. So these are possibilities. Further possibilities would be if, for instance, states include an option in a bilateral investment treaty that if an investor wants to rely on that treaty, it has to allow potential victims of the investment operation to make use of arbitration if the investor abuses their human rights. Now, let me turn to the applicable law. Arbitration rules have to offer legal security and predictability concerning the outcome of arbitration proceedings. Therefore, it is necessary to indicate rules for the arbitral tribunal on how to identify the applicable substantive law. It did not seem advisable to design substantive standards. The substantive standards can stem from a variety of sources, such as domestic law, contracts, human rights treaties, and soft law standards. Therefore, the rules need to be flexible enough to cope with this potential patchwork of norms stemming from different legal sources. This flexibility has to be combined with certainty, so that it is foreseeable for all parties to a dispute which norms will be applicable to their dispute. Granting a maximum of autonomy to the parties in choosing rules should guarantee the necessary flexibility. The default rule, in the absence of a choice of law by the parties, will ensure certainty. The Hague Rules follow the four-step approach of the UNCITRAL rules in determining the applicable law. Para 1 provides for the possibility of an agreed choice of law. Para 2 contains a default rule on applicable law. Para 3 allows for an express agreement of the parties for an ex equo et bono decision by the tribunal. And Para 4 directs the arbitral tribunal's attention to various additional binding rules that it may draw upon to resolve the dispute. Option 1, the clause on agreed choice of law in Para 1 uses law, rules of law, or standards. The idea is to provide the parties with the broadest possible flexibility in choosing the normative sources from which the applicable law is drawn. This may, for example, include industry or supply chain codes of conduct, statutory commitments, or other relevant business and human rights norms. Both parties must have agreed to apply these laws, rules of law, or standards. It allows applying combinations of rules emanating from different legal systems and from non-national sources. The same is true for the default rule on applicable law. It refers to the law or rules of law the tribunal determines to be appropriate. The change from law, as mentioned in the UNCITRAL rules, to law and rules of law in the Hague Rules allows for the application of rules emanating from different national legal systems or even from non-national sources. Otherwise, a tribunal would frequently be required to apply one legal system in its entirety, as national conflict of law rules often provide. The applicable law or rules of law determined by the tribunal under Article 46(2) only contains rules binding upon corporations under national or international law and may include international human rights obligations. Furthermore, when interpreting the applicable law, an arbitral tribunal will have to consider the potential direct or indirect relevance of international human rights obligations of any states involved in the dispute in whatever capacity. Article 46(3) reflects the text of the UNCITRAL arbitration rules and allows for exequat bono decisions if the parties have expressly agreed on this possibility. Article 46(4) adapts the UNCITRAL rules to the context of business and human rights and directs the arbitral tribunal's attention to various additional sources of binding rules that it may draw upon to resolve business and human rights disputes. Within industries where all relevant participants have committed to a certain level of human rights protection, a usage of trade may arise and bind the parties. This can be the case even where an instrument containing a choice of law does not expressly incorporate applicable human rights standards. Let me now turn to the duty of the tribunal to satisfy itself of the human rights compatibility of an award. Article 18(1) outlines the general principles underlying business and human rights arbitration proceedings. It contains the obligation to conduct the proceedings in a manner that provides for a human rights compatible process in accordance with the guiding principle 31F of the UN Guiding Principles. In line with this duty, Article 45(4) provides that the tribunal is under an obligation to satisfy itself that its award is human rights compatible. To fulfill this obligation, it will be appropriate to include some discussion on rights compatibility into the reasoning of the award. This requirement is part of the general requirement to give reasons and is one of form and not of substance or applicable law. It is meant to encourage the arbitral tribunal to consider the rights compatibility within the ambit of its discretion. However, it does not authorize the arbitral tribunal to disregard or alter the result required by the applicable law as determined in accordance with Article 46. Furthermore, the obligations to satisfy itself of the human rights compatibility of the award assists the tribunal in fulfilling its duty to render an enforceable award. It demonstrates that the arbitral tribunal has considered potential issues of compliance with public policy, which may arise in business and human rights arbitration. This concerns in particular those arising under the law of the legal seat of the arbitration and likely places of enforcement of the award. The Hague Rules contain a new Article 11 regarding the selection of arbitrators. Its key innovations include the requirement of demonstrated expertise by the presiding arbitrator or sole arbitrator in international dispute resolution, as well as one or more fields relevant to the arbitration. Independence as demonstrated by lack of involvement in the dispute, as well as a nationality distinct from that of the parties. And it explicitly mentions diversity as a desirable criterion for a tribunal, with an acknowledgement that diversity can come in many forms. In addition, the Hague Rules contain a special code of conduct for arbitrators. The code is based on best practices including but exceeding those of the IBA guidelines. The code's key innovations include strong duties of disclosure, a ban on double hatting involving the same issues, certain restrictions on former arbitrators, and the possibilities for the Permanent Code of Arbitration to create a Code of Conduct Committee to update the code as needed as best practices change. The Hague Rules also contain a detailed section on transparency. Based on many of the ideas of the UNCITRAL transparency rules, they provide a new set of default rules that lean heavily in favor of transparency during the proceedings. At the same time, the rule recognized that for business-to-business arbitration without a public interest, transparency may be neither required nor desirable, so that the tribunal may decide not to apply it. The scope of transparency is broad, to cover the publication of key documents such as the notice of arbitration and reply, the statements of claim and defense, and the decisions and awards of the tribunal. At the same time, the rule recognized certain information as confidential, notably the identities of persons protected by a confidentiality order for their safety, certain confidential business information, and information confidential under national law. It also provides for public hearings, subject to various exceptions for the protection of witnesses, parties, and counsel. All the information is to be stored in a repository, which the rules designate as the Permanent Code of Arbitration. The Hague Rules have been conceived as a uniform set of rules. However, parties may exercise their discretion to modify or opt out of certain provisions that do not respond to their needs in the dispute at issue. Certain model clauses have been developed in this respect. They are annexed to the Hague Rules on Business and Human Rights Arbitration. Now, let me turn to my last point. How do the rules address the need to protect parties, their counsel, and witnesses as their very personal safety, including in the country of the alleged abuses, could be at stake? Article 18.5 provides that for the protection of parties or their representatives in exceptional cases, it empowers the tribunal to protect the confidentiality of the identity of a party or of its representatives vis-à-vis other parties. This may be necessary where the disclosure of such identity is sensitive or may otherwise prejudice that party or its representatives. The tribunal may designate a specific representative of the other party who may be informed of the identity of a party or the representatives of a party who request such designation. All representatives so designated shall observe confidentiality in connection with this identity. Article 33.3 contains provisions for the protection of witnesses in situations of genuine fear. Specific measures that the tribunal can use may include the non-disclosure to the public or to the other party of the identity or whereabouts of a witness. The commentary provides various examples of such measures. Possible measures include expunging names and identity information from the public record, non-disclosure to the public of any records identifying the victim or witness, giving testimony through image or voice-altering devices or closed-circuit television, and assignment of a pseudonym. Closed hearings under Article 4 and any appropriate measure to facilitate the testimony of vulnerable witnesses, such as one-way closed-circuit television, are also possible options. The burden of proof of demonstrating a genuine fear rests on the person or party seeking the restriction. This person or party will have to show how the witness would be prejudiced by publicity. This may also depend on what information is already in the public domain. The concept of genuine fear should be understood as a subjective fear of harm to the person or their livelihood. A witness may have a genuine fear even if similarly placed witnesses have testified without retaliation against them. In line with this approach, Article 42, dealing with exceptions to transparency, confers the power on the arbitral tribunal to deem information confidential if necessary to protect the safety, physical and psychological well-being and privacy of all those involved directly or indirectly in the proceedings. Let me conclude with the famous words of Winston Churchill. Now, this is not the end. It is not even the beginning of the end, but it is perhaps the end of the beginning. So a lot will still have to be done in order to give the Hague Rules the broad acceptance they deserve. And for that, it needs the cooperation by many, including business, civil society, the lawyers, the governments, the academic world, and the arbitration community. Thanks a lot.